Hello, I'm Rupert Jackson, a judge in the Court of Appeal. For reasons beyond my comprehension, 9 years ago I was asked to take a serious look at the costs of civil litigation and to make proposals to promote access to justice at proportionate cost. Ever since then, in one way or another, I have been involved with that project. I produced a report in January 2010 which gave rise to what may perhaps fairly be called a certain amount of controversy, but which was in the end implemented during 2013. I believe that those reforms are very beneficial. Others take that view, although not everyone does. Recently, I have been asked to undertake a further review. You may recall that in my first report I made some proposals for fixed recoverable costs, and I said that when those reforms had bedded in, we would need to look again at fixed recoverable costs and to extend their scope. Well, in November of last year, I was asked to carry out a further review in order to propose extensions to the fixed recoverable costs regime. I duly did so over the period January to July of this year, which was the period allotted for my second review. Yesterday, on the 31st of July, I published my report, and here it is, and I've been asked to give a brief account of the recommendations. The fast track is designed for cases which can be tried in one day and will have a limited amount of evidence. Most personal injury cases in the fast track do now have fixed costs in accordance with recommendations which I made 7 years ago. However, there is a chunk of cases in the fast track where costs are still at large. What I have proposed in my report published yesterday is that we should fix the recoverable costs for all cases in the fast track. I have a panel of 14 assessors to advise me, including 2 economists. We have done a great deal of analysis on recent data from fast track cases, and in my report I have put forward a proposed grid of fixed recoverable costs for all cases in the fast track. The fast track has a streamlined procedure already. Cases proceed from issue to trial without any oral directions hearing. Most directions are given at the beginning, and so cases in that track are readily suited to a fixed costs regime. There has been much more debate about cases above the fast track. Some time ago I suggested that we should be fixing the recoverable costs for lower value cases above the fast track. That proposal generated a great deal of debate. During my recent inquiry, I have amassed a great deal of evidence about the costs incurred in lower value cases above the fast track. I have put forward proposals for fixing the recoverable costs for cases above the fast track level where the sum in issue is no more than £100,000, where the trial can be completed within 3 days, and where there are no more than 2 expert witnesses on each side. In other words, my proposals are aimed at the less complex, modest value cases. Many of the stakeholder groups who made submissions during my recent review urged upon me that if I was going to fix the recoverable costs for cases, I would need to do something to reduce the amount of work that the lawyers have to do. I have taken heed of those urgings which come from the bar, solicitors, and many others. I have proposed a special procedure for these fixed cost cases. They will go into their own track, a newly created intermediate track. The disclosure of documents will be greatly restricted. The evidence on both sides will be restricted, and there will be limits on the length of the expert reports. Issues will be identified at the start of the case, and at the first case management conference, the judge will give directions limiting the admissible evidence to those issues. The idea is that cases in the intermediate track should proceed swiftly and at proportionate cost to an early conclusion. That is what the public interest requires, and that, I believe, will work. Very recently, the Technology and Construction Court, the Chancery Court in London and the regions, the Commercial Court and the Mercantile Courts have all come together under a single umbrella to form the Business and Property Courts. They're headed by the Chancellor. The idea is that cases will move freely between the different parts of that court, and judges will have the ability to sit in different parts of the business and property courts. That's a very positive move. It will recognise that the traditional distinctions between the Technology and Construction Court, the Commercial Court and the Chancery Division have really passed their sell-by date. Now, I recognise that business and property cases pose special problems. I received a very powerful submission from the Federation of Small Businesses. They said, our members cannot afford to litigate as things stand. They need a fixed costs regime for claims up to £250,000. They need robust case management and slick court procedures. There's been a lot of debate about this. A fair number of stakeholders support the views of the Federation of Small Businesses, but equally a fair number of court users do not. And they say they want the full panoply of litigation without such constraints. The City of London Law Society put in a very well-reasoned submission to me saying that business cases should not have fixed costs. But at the end, they rather sheepishly admitted that a minority of their members actually wanted fixed costs, and that minority was proposing a pilot for fixed costs in cases up to £250,000. I held a seminar on business cases in Birmingham in March of this year, and again the views were polarised between those who thought fixing recoverable costs would promote access to justice and those who thought it would have the opposite effect. There was a general agreement that if I am fixing recoverable costs in business or business and property cases, I must do something about the procedure. In most of these cases, you will have hard-nosed businessmen on each side. Very often, they will be prepared to accept that if they win, they won't recover more than X pounds, in the knowledge that if they lose, they won't have to pay more than X pounds in costs to the other side. What I have proposed is that we should run a voluntary pilot in certain designated business and property courts. The pilot will have rules greatly restricting the expert evidence, the factual evidence, the discovery of documents and so on. So the same principles as in the intermediate track, but different details of the rules tailored to the needs of business users. Now, this pilot will be called a capped costs pilot, and the recoverable costs for each stage of the litigation will be subject to a specific cap, and the overall recoverable costs will be capped at £80,000. So any case which goes into this pilot is one in which both parties know that if they lose, their costs liability will not be more than £80,000, and if they win, their costs recovery will not be more than £80,000. This will be a voluntary pilot. It will be voluntary on both sides. cases will only go into the pilot if both the claimants and the defendants agree that it should go. A voluntary pilot has many benefits. First, it enables us to see what is the take-up. Do the market want this kind of regime or not? Informal feedback, which I have received, is that there is likely to be a significant take-up, but who knows? If there is a significant take-up, it will show that there is a need for a capped costs regime with streamlined procedures for business cases up to a claim value, that is, of £250,000. The other great benefit of a pilot is that you can see how the rules work in practice. 7.5 years ago, I proposed another package of civil justice reforms, which have all now been implemented. I piloted some of them for several years, and those pilots enabled us to see what were the glitches, what were the teething troubles, so that we could iron them out before rolling out the new procedures nationally. I hope that this voluntary pilot for business and property cases, if it goes ahead, will serve that additional function. I should add that my report is only making recommendations, in the same way that my previous report was only making recommendations. It will be for the government and the Rule Committee and indeed the senior judiciary to decide whether or not they accept those recommendations. All I can do is to put forward reasoned arguments and to set out the evidence upon which I rely. Clinical negligence is, so to speak, a hot potato. There are very strong feelings on both sides. I have had representatives of the National Health Service and the National Health Service Litigation Authority, now called NHS Resolution, telling me that the claimants' costs in these cases are outrageous. They are crippling the National Health Service and sucking funds from frontline medical services. I have had claimant organisations stressing to me the importance of proper compensation for patients who are injured by negligence and stressing to me the complexity of the cases. The claimant side say these cases are complicated and the costs are bound to be high. Clinical negligence cases have a unique character. They are very often of acute importance to the parties on both sides, the injured claimant, the parents who've lost a baby or whatever, and equally very important to the doctors or nurses on the other side whose professional reputation is in issue. Another feature of clinical negligence cases is that a large number are of very low value. Now, I know there are some huge clinical negligence claims where a baby has been damaged by lack of oxygen at birth and so forth, and I did some of those cases when I was at the bar. But the great majority of clinical negligence cases do actually have a damages value under £25,000. So the problem in clinical negligence is that we have this great raft of low-value cases where the costs are very high. I haven't in my report put forward a grid of fixed recoverable costs. I have, however, ascertained during my consultation process that there is a willingness on both sides to develop a bespoke procedure for clinical negligence cases. This means the claimant representatives and the defendant representatives come together. They identify in detail what letters of claim should contain, what reports should accompany them, what response letters should contain, what disclosure should be given, what reports should be produced by the defendants at an early stage, and so forth. Now, the development of bespoke procedures has worked in other areas, and it has been possible to graft onto bespoke procedures grids of fixed recoverable costs. My recommendation in the clinical negligence field is that the Civil Justice Council should set up a working party with representatives, senior representatives on both sides, to develop bespoke procedures for clinical negligence claims up to £25,000, and then to graft onto that a grid of fixed recoverable costs. You can't draw up such a grid without first identifying the procedures. You cannot put the cart before the horse. One of my main recommendations for judicial review was that judicial review cases should be subject to qualified one-way cost shifting, a procedure now popularly known as QWOCs. I also recommended that for personal injury cases. In respect of personal injury cases, my proposal was accepted, and we do now have QWOCs for personal injury cases. I have come back to the matter of judicial review in my recent review. I accept the government haven't rejected outright my previous recommendation, but they haven't implemented it, and 7.5 years have elapsed, and so I'm inclined to the view that they probably won't implement it. What I have proposed this time round is something more moderate from the government's point of view than QWOCs. I have proposed that we should extend the Aarhus rules, which currently apply only in environmental claims, to all judicial review claims. Under the Aarhus rules, a claimant in an environmental judicial review claim can opt into a system whereby his costs liability will be £5,000 at most, or £10,000 if he's representing a business, but the costs which he can recover if he wins will be up to £35,000. Now, this looks a bit uneven. It's not as uneven as a QWOCs regime, and it recognises that in many judicial review claims you have the individual on one side and the state on the other side. These claims are of constitutional importance, and litigants should not face a crushing costs burden if they fail. Don't forget that these cases only go forward at all if the court has given permission at the outset. So by definition, you won't get a totally unmeritorious judicial review claim going forwards towards a full hearing. Recently, the Aarhus rules have been amended so that the costs protection from the claimant can be lifted to a higher level or removed if the claimant is very wealthy. And likewise, the claimant's potential costs recovery can be lifted if that is appropriate in the particular case. Now, I'm not going to get into the debate about the recent amendments of the Aarhus rules. From the point of view of claimants, they have some good things and some bad things. But they are, in essence, a modified version of QWOCs. I have recommended that these Aarhus rules should be extended on an optional basis across the whole landscape of judicial review. If the claimant doesn't want it in a particular case, well, the claimant need not opt in. But it's very important that we recognise the constitutional significance of this segment of litigation.